Yay. Okay, good afternoon, folks. I'm Karen Reed. I'm the Task Force Facilitator. If everybody could get settled in and we'll get this meeting started. As in previous meetings, a couple words to start. That we will not be having a public comment hearing at this meeting, but you are encouraged, if you're a member of the audience, to complete a comment card. There are a pile of them at the back of the room, and we circulate your comments to the members of the task force at every meeting. Also, we will be having a public hearing in September where folks will be able to come up and give verbal comments, and the co-chairs will be speaking to that in a moment. I wanted to just go ahead and start by letting folks know we have two new people that are joining the staff support group. Fire Chief Bob Downey, I think he's Deputy Fire Chief, right? Assistant Fire Chief Bob Downey, and I don't think he's here today. And also, he's with the City Fire Department, and also Ashley Lammers Johnson, who couldn't be here today. He's the Executive Director of the Everett Housing Authority. So those two gentlemen will be joining the table with the other city and county folks to participate in the discussions as we go along. I'd like to ask folks to go around the table now and introduce yourself and, if applicable, the agency that you work with or group or business, and always use the microphones. You may have noticed what's different today. We have microphones everywhere. They've found as many microphones as they possibly can. So we're still having some folks that are having trouble hearing. So please do use the mic if you want to speak. Pull it towards you at least about 6 inches away to really get heard. And just note to self, the mics are always on. So commenting about what they're wearing, probably not a good idea. Okay. Thanks for that. And I didn't check to see if we were okay. Are we okay now? We're okay. My apologies. One last note before we started. At this point, I think if we stay on track today still, our agenda will go at least about 5 minutes over past 6 o'clock. Will that be okay with folks? If you need to leave, go ahead and leave, but just heads up, we're going to try to carry through and finish by 5 after 6. Let's see here. Thank you again for the good comments at the end of the last meeting. That was really helpful, and I appreciate everybody staying in learning mode. Today we're going to start to get into some solutions and ideas for solutions, but still try to stay in some of that learning mode as well and hear what people are really saying and why they're saying it. And we'll need to continue today to be able to talk about issues of crime in the criminal justice system without assuming that all the crime that we're seeing is being committed by homeless people. There are certainly non-homeless people that are committing crimes downtown, and certainly all criminals are not homeless, and all homeless people are not criminals. So again, it's both of those groups that are bringing different issues to the downtown that we're trying to deal with. It's two sets of issues. They overlap, but they are not synchronous completely. Okay. I'm going to turn this over to, let's see. Well, let me just say another couple words about the agenda. Today, our main point is to have two big panels. We're still on this course of learning. Our main panel, the first panel, is on the criminal justice system and how it interacts with the chronically homeless and other folks in our commercial areas. Where is traditional policing effective? Where is it not so effective? What are folks trying that might not be really traditional here? You'll see that nationally, there's some materials in your packet. Nationally, a lot of work is being done to develop alternatives to deal with homeless populations in the criminal justice system that is an alternative to criminalization of behaviors. And we'll talk a little bit about what's happening in that vein here in Everett. The second panel is around outreach. There's a discussion guide and some information from Linda Grant at Evergreen Manor. We're going to have a roundtable discussion. It's going to be really open-ended, so stand by for that. For folks who are part of the outreach system now to talk about what you're doing and what's working, and for everybody to observe what gaps they might see and what ideas they might have about outreach. And the idea here as we start that outreach discussion is to sort of think longitudinally about the homeless population. Again, they're not the only folks we're concerned about, but if you think about outreach as you're first getting somebody into the lifeboat, and then over time you try to find them a place where they can get on that path to recovery. So we're starting with outreach. How do we first connect with these folks? And then at our next meeting, we're going to talk about crisis interventions and temporary shelters. And then we're going to talk also about long-term permanent housing solutions. So that's where this longitudinal approach to looking at and learning about what's going on with respect to the homeless population. I'm thinking. Also, you will see that if there's sufficient interest in on your part on the discussions around criminal justice or outreach, we're going to ask if you want to create task force subcommittees of 3, 4, 5, 6 people who might want to go meet once between now and the beginning of October and come back to this group with some recommendations, perhaps more focused recommendations around those issues for consideration by the task force. So be thinking as you're hearing these presentations if being on one of those subcommittees is something that you would like to do. We'll want to have a sort of a balance of folks represented on them if they are created, and we'll have staff support to help you do the work of the subcommittee and their advisory to the task force. You'll be coming back and telling us what thoughts you have. We don't have to do subcommittees, but if you'd like to do that, this is a good point to launch those after we hear these panel discussions. Okay, so now I think that's it. And I would like to ask Chris and Sylvia to do some kickoff remarks here.
Introductions.
Oh, yeah, sorry. The introduction thing. Okay, so soon and I'm forgetting. I'm going to hand this to David.
David Hall, City of Everett. Dan Templeman, I'm the Chief, Everett Police.
Bob Dobler, Gamut 360 Holdings.
Craig Scott Dahl the Downtown Everett Association.
Brent Spire, Under Sheriff's and Snohomish County Sheriff's Office.
Linda Grant, Evergreen Manor CEO.
Georgia D. McLeod, Neighborhood Council.
Chris McDowell, Everett Public Schools.
Cassie Franklin, Cocoon House.
Suzanne Duff, the Salvation Army.
Bob Reese, Volunteers of America.
Ed Peterson, Housing Hope.
Winnie Corral, Lutheran Community Services Northwest.
Flora Diaz, Alone None Law Group.
Megan Dunn, Human Needs Commission.
Renee Quistorf, Renee's.
Alan Dorway, First Presbyterian Church of Everett.
Mike Purcell with Journey Church in Everett, and I'm filling in today for Matthew Savage.
Glenn Bachman, Everett Mall, and also Port Commissioner.
Mark Niceother, Sea Dog Corporation.
Tom Sebastian, Come South.
Ken Starks, Snohomish County Human Services.
Sylvia Anderson, Everett Gospel Mission.
Chris Adams, attorney in Everett and then chair of the Planning Commission. All right, we have a couple co-chairs remarks that we want to go through. Some of it's just housekeeping, and I'll try to keep this short so that way we stay on schedule. The first thing is at our next meeting, as Karen mentioned, we have a few new members that will be welcoming, so I'll welcome them at that point. One of the things we wanted to do is appreciate the discussion at the end of the last meeting, everyone going around and providing the comments that you did. We hope we're going to have more of that going forward, but we also appreciate everyone's patience as we're going through this education process and as we start to work towards the discussions that we'll have in the future and action items that will be on the agenda, or that we'll be working towards hopefully down the road. So we just want to recognize everyone in terms of that good discussion. I said this last time, I hope everyone's reading the lavender pages at the end of your materials. It's really important that we go through those. We're asking the public to do that in writing so we have a chance to go through those. So if you haven't already, make sure that you please do that. One of the big things that we've been working on behind the scenes is we're going to have a public hearing, and this is an opportunity for verbal comment from the public in terms of adding to the discussion that we're having. We're going to have that in this room on September 9th from 7 to 9 p.m. And the co-chairs will be at that. The task force members are welcome to attend. You're not required to, but if you're available, please do. The process is going to be an opportunity for everyone to provide comment from the public. We'll probably have about 3 minutes for each person to speak, and we're going to take detailed meeting minutes, and we're also going to record that meeting so that way the task force members can hear those comments if you're not able to attend. If you do attend, we'll have an opportunity for you to either sit at the podium or sit in the audience, whatever you're more comfortable with, and we'll kind of depend on how many task force members we have show up. And it's really, it's the only other thing I would add is it's really a good opportunity, I think, if you can attend, because we do want to make sure that we get as much input into the discussion that we're having. So if you can, please do attend.
So in keeping with that, the mission is going to have the focus group that for folks who are experiencing or have experienced homelessness so that they feel comfortable talking about the issues and some of the solutions that they have that we've heard a lot about. So it's going to be September 23rd at the Mission. We don't want the whole task force to be there because we don't want folks to feel overwhelmed by us. We want them to feel comfortable in that setting. So 3 or 4 people, if you'd like to attend that focus group at the Mission, please sign up. There's a sign-up sheet in the back, and you're more than welcome to be there. We'll take good notes, and we'll report back on some of the solutions that they're talking about. We also have some questions from the Mission that we've kind of developed that we want to ask them, but there are cards up here that we'll pass around. So if there are things that you would like to ask and you're not going to be there, you're more than welcome to submit those questions, and we'll try to make sure that we get as many of them asked as possible. And then, in addition to that, the field trips are getting ready to start, so we really want some cross-pollination. So if you're a service provider, we would love for you to go on the business tour, and if you're a business person, we'd like you to go on the service provider tours. So in the back, there's also sign-ups. There's 6 different field trips. As you can see, the sign-ups are back there. So we want to thank the folks who are willing to have tours happen at their facility. So Craig Scott Dahl, thank you. Linda Grant, Evergreen Manor. Tom Sebastian, Compass Health. I guess I can thank myself and John Hull. Pastor Doorway, we appreciate you, and Wendy Grove from Recovery Cafe. So we want you in the next couple of weeks, I think that information is all back there, to please sign up today and make sure you go to the tours. Ask lots of questions, because you're going to be right in the thick of things, whichever side you go to, okay? And I think that's it. Thank you.
There is a handout in your packet that describes the list of all the tours and the dates and the times. You'll find that in there. I think it's behind our meeting summary. So as we go through today and you're listening today, take a look at that list and think about which one of those might work for your calendar. And remember to sign up before you leave today. And please remember to give us your thoughts about any questions that you think might be interesting to ask at the Gospel's Homeless Focus Group, and hand those back to me before you take off tonight. All right. With that, we're down to the point on the agenda to approve the meeting summary from meeting 2. So folks have had an opportunity to review that. I notice there's an error on the attendance. Glenn Bachman was not there. He had his alternate was attending for him, and Bob Dobler was here. So my apologies for that error, but with that correction, I would ask if there are any other corrections or additions to the meeting summary. These are a little longer than the usual meeting summaries, and again, these are all posted on the city website. For those of you in the audience who would like to take a look at any of the materials that we're looking at today, they're all posted on the city's website. If there are no corrections, I would happily entertain a motion to approve. I'm sorry, Flora? Was that a motion or a?
Well, it's a tiny correction. It's
Okay.
just a typo on page 5, close to the bottom. It says 22.000 units.
That should be a
countywide will
comma.
needed. It should say 22,000.
Thank you.
Just a tiny typo, but it's a big number difference.
That's a big number. All right, so
With
that
that
22.
correction, I move to approve.
Thank you, Cassie. Do I have a second?
Second.
Thank you, Georgia D. All in favor? Opposed? All right, thank you. We'll call those approved, and as amended, we'll get those posted. And now then, where are we? So let's look at the other materials. There's meeting materials in your packet that we might want to just take a quick look at. This is where we look at how far did we get in answering some of the questions you've raised before, and what else have we sort of come up with. Behind the meeting minutes in your packet, the first thing you'll see is an updated contact list. A few more people have been added to the table and/or as alternates. So you can, and we'll try not to do this at every single meeting, but so far things are still in flux. This new contact list can replace the one that is in your binder currently. Right behind that, you will see the one-page summary of all the tours that Sylvia spoke to. Take a look at this, and behind that, there's a couple pages with some calendars of August and September, so you can more visually see the dates and times that the tours are going to occur. And again, we want you to sign up for those. You can do that at the break and before you leave tonight if you don't get to it during the break. Behind that is this PowerPoint, just to get to a recap of last time. You guys were great and filled out homeworks that identified things that you were concerned about. Remember, the last meeting was really about getting all the issues out on the table and seeing where we had a lot of commonality in terms of perceptions and concerns. And just really quickly, this slide here was the list of the concerns that were most frequently identified by the task force members. And then the next slide, these were the underlying causes most frequently mentioned by folks, and there's a lot of overlap between those two things. And these may end up being categories for us to look for solutions in, so that might be something to think of as you're listening today. And then in some, there was a lot of commonality in terms of the issues and concerns and belief about underlying causes that people identified. There were some important differences we may have to work through, and lots of ideas about ways to improve things. So that was great. That's all I had on that, just to remind us what we went through last time. The next page in your packet is a very humble attempt to try to capture some of the math around the resources that the county throws at human services. Countywide, almost $84.5 million in 2014. And this is a one-pager that summarizes that large, colorful spreadsheet that was in the materials that Ken provided last time. So you can see where that money comes from, sort of equal piles from the feds, the state, and the county, and then where it all goes. And lots of it's going to housing. That's the single largest, housing and community services is the single largest category. So that's kind of an interesting one-page download. And behind that page in your packets, there are two city council resolutions that were also in the material last time. And Dave Koenig from the city, who gave the great presentation of the last time about the city's vision and where the comp plan is going, he's in charge of overseeing the process by which the city makes the decisions about where to allocate its community development block grants and locally raised monies towards human services. These two resolutions identify in great detail how much money the city is currently allocated to human services and housing and community service type programs, and where that money is going. And we want to just pull that out again for you to take a look at. Again, there's federal money, the CDBG money, community development block grant money, that's one pile. The city also raises money, takes some of its general tax revenue each year and allocates that about $3 per capita towards human services needs in the city. And this will give you a better idea where that money is currently going. Okay, behind that, if you're still hanging in there with me, is a one-page document, which is the summary of the questions that we have tracked to try to follow up on for you guys to date. This is a running list, which will be in your packet every time. The very first question, and I don't know, David, whether you and Dr. Fenn want to speak to this, at the bottom line is to really get good data relative to homeless individuals and crime is something that would take a data dive into the county's data banks. It would probably require a consultant contract, which folks do not have funding for at this time. So do you want to?
I think I can explain it any better than that. Yeah.
So there's a little more data that David's going to speak to around this issue, and we were chatting with the co-chairs and thinking maybe one other way of getting at this might be to ask the police if they could identify physical locations, buildings in commercial areas that receive the most calls for service. And so we'll follow up with you and see if that's another way of getting at this data, because going at it through the county's jail database did not apparently help us. So I'll talk to you, Chief Templeman, after the meeting and see if we can try to get a little more data there, but what we were hoping to get to you is not going to be available. We've answered for you questions 2, 3, and 4, and question 5, detailing the housing that's been built in the county since the 10-year plan to end homelessness was adopted. That is in process. And we're going to be working with Ken and his folks to get that information. So that's where we're on that. Behind that, you'll see 2 web links that Marilyn Rosenberg sent me and said that she thought folks might be interested in watching these 2 short YouTube videos. She thought that they had some creative ideas about addressing challenges on the street. So I just included that for your information. And that, I think, brings us down to our first task force. And David is going to be kicking that one off here. And again, we're listening for both ways to address both problems that are just plain old folks that have homes and are committing crimes, and ways of dealing with the homeless who may or may not be committing crimes, and how is the system working?
Our panel discussion today is going to focus on the criminal justice system. We have 4 speakers: Judge Laura VanSlyck from our municipal court, Lieutenant Bruce Bosman from EPD, Hill Kamen, our lead prosecutor, and Laura Baird, one of our public defenders. I'm just going to give a brief introduction and a few general observations by way of context for that discussion. I only have 5 minutes, so I'm going to talk fast. We're going to be talking mainly about the city's criminal justice system, which means misdemeanors. The city has jurisdiction over misdemeanors. Felonies are handled across the street by the county. We prosecute about 5,000 plus misdemeanors a year, mainly through the traditional arrest, prosecute, jail model. And I'd like to make a couple observations about that model that kind of sets the stage for this discussion. The first is that it is the surprisingly expensive way to handle these problems. You've got some cost information in a handout that looks like this. I won't go through all the numbers, but in broad overview, everyone knows that, of course, we employ police officers, prosecutors, fund the operation of the municipal court. The marginal cost of each prosecution for those elements, according to the Washington State Institute of Public Policy, is about $1,500 per misdemeanor. What a lot of people don't know is that we also pay for public defense. The Sixth Amendment to the U.S. Constitution guarantees everyone accused of a crime the right to a lawyer, and if that person cannot afford an attorney, one is appointed at public expense. And most of the people prosecuted for misdemeanors in our municipal court cannot afford a lawyer. We last year had more than 3,000 indigent defendants, meaning that we paid for lawyers in more than 3,000 cases for a total of just over $1 million. We, of course, also pay for jail, both for defendants awaiting trial and for offenders who are serving time pursuant to a sentence imposed by the court. Jail currently costs $95 per booking each time somebody is booking in jail, then a $65 housing fee. We had over 3,000 bookings last year and over 37,000 housing days. We spent just under $3 million incarcerating individuals in the Snohomish County Jail. So handling misdemeanors with this traditional model is very expensive, and it's getting more expensive because of some issues at the jail that Sheriff Trineri will talk about next time. The cost of jail is going to go up next year pretty significantly. The housing fee is going to go up to about $85, and for individuals with mental health concerns, to reflect the greater cost of caring for those individuals, $200 per day. So we estimate that next year's jail bill, if nothing else changes, is going to be well over $4 million. And if you start adding those numbers together, you see that the average cost of handling each misdemeanor next year is going to be over a couple $1,000s for your standard misdemeanor, and for people experiencing mental health concerns, a smidgen over $4,000. So, you know, when I hear somebody look at the street and see, you know, 5 folks on Colby talking to themselves and sprawled out on the sidewalk, and somebody says, why can't we just have police get those people off the sidewalk? You know, the answer is probably, at least we have to ask ourselves, do we want to spend $10,000, $12,000 to get 5 people off the street for 10 days? The cost of indigent defense is also going up. A federal case, Wilbur v. Mount Vernon, this past year, significantly ratcheted up the level of representation that's expected of a public defense system. It requires more time be spent by public defenders with their clients, more motions be filed, more investigators be used, more trials occur, more experts be used at trial. And this is going to raise our indigent defense costs next year by something approaching $1 million. So, independent of that, the Washington Supreme Court adopted caseload standards, limiting the number of cases a public defender can handle in any given year to 400. That means we're going to have to hire more public defenders to represent the same number of defendants, also driving our costs up. So the rationale behind both these changes, of course, is to improve the quality of public defense for indigents in our court system. The secondary motive of the organizations, social justice organizations, the ACLU, the Washington State Bar Association, the courts, in pushing for these changes was to say to the municipalities, if you're going to charge people with a crime, you're going to need to pay for a real criminal defense, the kind of criminal defense you would expect if you were charged with a crime. And by the way, maybe you should be looking at the full range of behaviors that you're treating as criminal behaviors and asking yourself, do we really want to treat these as criminal behaviors, or is there a more cost-effective and effective way to treat these behaviors? The good example of behaviors that or of a social problem that we tend to treat with the criminal justice system is mental health. We're all familiar with the story of deinstitutionalization. Several decades ago, we made an effort to move people out of large psychiatric institutions and into community treatment. We did the first part. We didn't fund the community treatment part, and as a result, we have thousands and thousands of people with mental illness on the streets, and far too often also in jails and prisons, to such an extent that the largest psychiatric facility in the United States is now the Los Angeles County Jail, and in most states the largest facility is a jail or prison. The consequences of handling what some people would say are essentially social problems can be seen right here in our Stonewall County Jail. Some of the information that Robin Fenn talked about at our first meeting, and you've got a handout that looks like this. It needs assessment that's performed in the jail. Indicates that of the people that were interviewed, the inmates that were interviewed, 56% had been homeless at some time in the previous year. The vast majority of folks had reported substance abuse or mental health issues. Of the 56% who had been homeless, 100% had mental health issues, substance abuse issues, or both. And 22% had housing when they went into jail, but expected not to have housing when they got out. So jail may not be the best place for some of these folks. As you can see, people lose housing, but they lose a lot of other things. They lose jobs if they have one, they lose relationships. If they are sleeping in their car, they can have their car impounded, maybe sold while they're in jail. They've lost their only shelter. And often are worse off when they get out of jail than when they went in. So a lot of the things that we're trying to do in the criminal justice system, the innovations, are strategies for moving folks whose fundamental problem is not criminality, but a social or psychological or economic problem, moving them out of the criminal justice system and into the social services system, which can better meet their needs. And some of the strategies I think we'll be hearing about today from Judge VanSlyck probably our Community Justice Alternatives Program. Lieutenant Bosman may talk about diversions such as our triage facility, and we're going to hear about outreach from a number of people with folks later, getting to folks, meeting their needs before they even come into contact with the criminal justice system. So that's kind of the framework for our discussion today. I do want to just briefly touch on a couple of other things. There are traditional legal tools that are used by a number of jurisdictions to address these problems. The executive summary that was distributed from No Safe Place, which is provided by Cassie Franklin, thank you, makes a pretty compelling argument for why we shouldn't be using those tools. I will just say that a number of jurisdictions do use them, and some will tell you they think it is a useful tool. But from what I've told you about the increasing cost of handling misdemeanors, and also what we'll hear a little bit more next time from Sheriff Trenery on, which is periodic booking restrictions at the jail that limit our ability to use the jail for many misdemeanors. Those options aren't very realistic for us anyway. So with that, I will turn it over to our speakers. Thank you.
And speakers, would you like folks to hold questions until after, and then we'll just take, after each speaker, we'll entertain some
Yes,
questions?
please. Yeah.
Okay, we've got about an hour for this panel, including questions, and the 4 speakers, just so thinking about time, et cetera, because I'll have to harass you otherwise. Okay, have at it.
Let me know if you can't hear me. I don't use the microphone very often. Lieutenant Bruce Bosman, Everett Police Department. Throughout my short presentation, if I refer to criminal or chronic nuisance street activity, it can cover a variety of activities, not necessarily criminal, could be perceived criminal or nuisance activity, or actual crimes. One of the things I want to do is I want to talk about our traditional approach as far as law enforcement response to these chronic nuisance street activities, things that have worked well, some of the challenges we have, and then some of the ways that we're looking to the future for a more effective way to respond to this activity. I'll kind of walk you through what a typical police officer does when he responds to these type of issues. The first thing that they do is they have to investigate life safety issues. Number one priority, is this a life safety issue for the person that we're contacting, for the public, for ourselves, and does it require immediate intervention? We're also looking for medical issues. And again, this could be something very emergent. Is this someone that's injured? Is it someone that's suffering from substance abuse issues? That could be life-threatening, or it could be pregnancy or a variety of other medical concerns to where we need to get EMS support in there. Environmental concerns are always a factor. Sometimes it's safety based on location, in the middle of a street, on railroad property. It could be environmental in that it's the weather, exposure to the elements, heat or cold, to where we have to get this person to a better place and out of that environment. We've heard a lot of talk in this task force about it already, but mental health issues are something that the officer is evaluating. What's the best approach, the best way to deal with this person? What kind of resources do we have? Do they understand and do they have knowledge that they're committing whatever this chronic nuisance activity is, knowledge of potential laws that they've violated? And have crimes been committed? I think the public perception is that we show up, we're looking for a crime that's committed, we take them off to jail, and that's what I'm hoping this clarifies a little bit. We're looking at a variety of responses. Possibly crimes are committed and maybe not. It could be that it's something resolved as simple as a civil infraction. Maybe that was the only activity that we found at the end of our investigation. Medical support, a consideration that we have is it safe? Is the scene secure for aid? We have to relay information to get the EMS in to make sure that they can safely operate, that they're not at risk because of a violent person that we're dealing with, or those environmental factors that I was talking about. One of the things that we may do is relocate this person as a way to remedy this situation. Relocate may be to shelter, a temporary shelter, for example, such as the Salvation Army does during inclement weather, or it could be something established like the Everett Gospel Mission. It might be the detox facility. The jail might be appropriate. Hospital, Compass Health Triage Center. With all of these that I've talked about, and I know that the group's already discussed limitations, and I don't want to take away from the sheriff's presentation next week, but we have limitations based on bed space, based on medical condition, mental health, suicidal considerations, and that's with all of these. We have some of those considerations where that may not be a viable option. If it is an arrestable offense, is it a mandatory arrest or is it something that's discretionary? Because that's a factor in how we're going to respond. Booking into jail may be an option, but again, we have to look through and assess that individual, be in communication with the jail to see if this is a bookable offense, and if there's room, or if there's room in their special housing in their 39-bed max that they have. Citation may be an option that we respond. So it's still an arrest. And this is a part that I've tried to explain and help educate the public, is that sometimes the best course of action is to leave that person with a piece of paper with a court date on it, still holding them accountable for a crime that occurred, but not a physical arrest taken to jail. They're still just as accountable and potentially charged with that crime. It may be that we refer charges, so we just write a report, refer the charges to the prosecutor's office, and then they're held accountable if that is filed by the prosecutor at a later date. And again, I've talked to a lot in the neighborhood groups over the years, and when they see that response that we leave, don't even leave the person with a piece of paper, the perception is that we haven't done anything with this individual, when in fact we may have in this case. In many cases, there's no action taken at all as far as physical action. There may be conversation, there may be resources, information that's related to the individual, there may be a warning that was issued, but in the end of all this investigation, the result may be no crime was occurred. There is no nuisance activity that we can move forward with enforcement on, and that's not the right method or the right action, and the perception of the public is no action was taken at all. We realize that these traditional responses to nuisance activity are not always effective in changing the behavior. We also realize that sometimes enforcement of this activity pushes the problem elsewhere, and I know that this group has already talked about that a little bit. Some of the things that the Everett Police Department has done to look at alternative responses to this kind of nuisance activity is training up some of our officers in CIT, crisis intervention techniques, how to communicate better with people that are in mental crisis, how to do that safely, and with good communication can get to the heart of what's the best response and the best way to deal with this person. Another tool that we have is the chronic nuisance property investigation. This is a system that's more designed for the property where the chronic nuisance activity is taking place, but it's been very effective at reducing that activity. There's several in the room here that I've worked with several parts of this process, and it's very effective, giving them the tools, for example, do not rent lists for some of the motels, trespass notices to educate people on where they can and can't be, systems to help owners be responsible and to dissuade the criminal or nuisance activity. Another big piece is education of the public. We've been doing this through our crime prevention officers. We've been doing it through attendance at neighborhood meetings, trying to educate the public on what is criminal activity, what is suspicious activity, the proper way to respond, the way that they shouldn't respond, especially the ones that can get them in trouble or in unsafe situations. Recently, we went out and we looked abroad. We went to Santa Monica, California's police department. They have a program titled Law Enforcement Response to Homelessness. This is a very intriguing program that's been very effective for them. I hope to talk, or I hope the group looks at this later on. I believe they're going to, because it provides a holistic approach in responding to criminal or chronic nuisance activity. Our goal is to better inform the public of our capabilities and our limitations, to stop the frequent utilizers from engaging in chronic nuisance street activity, and to increase the quality of life in the community. And I believe we're going to hold questions until we're all done. So next speaker.
I thought we were going to do the opposite. We're going to take some questions between each speaker. Is that,
I'm okay with
is that
any way
okay
you want.
or what would you guys rather do? I thought that's what we were chatting about. Would you guys rather go through everything?
All going one after another, and then the questions could be directed whichever direction.
Okay, you guys can all stand behind the microphone at that point and be ready
that
to
works.
jump. Okay.
Thank you.
Thank you, Lieutenant.
Good afternoon. I'm Hill Kamen at the City Prosecutor's Office. And the way that this panel has been organized is that we're speaking in order of a way that a criminal case might move through the system. So after police contact an individual, that case enters into our office either through an arrest and a booking into jail or a citation or a referral. And you've heard talk about the traditional system of arrest, prosecution, jailing, and one thing I want to point out is that that system in many ways is effective for what it was built to do. So if you are stopped for a DUI, the officers are specially trained in investigating those type of cases. They know exactly what to do to gather that evidence, to interact with that individual, to bring that person either to jail, to get them off the streets, get their case started. The prosecution is trained very well in dealing with those cases, getting them to court, trying them, getting that person convicted. The court does well imposing conditions, mandatory treatment, ignition interlock devices. It works well. But when we take this tool, which is the criminal justice system, and apply it to the street level social issues that are discussed as part of this panel and part of this task force, it doesn't always work well as it does for these other traditional types of crimes. And so what I'm going to do is talk about two areas in particular where we experience gaps in the system and where there are great opportunities to do something different and use different tools than the traditional application of the criminal justice system. The first one of those is the gap between the criminal mental health system and the civil mental health system. So as a threshold matter, when you are charged with a crime, you have to be competent to be prosecuted. And that threshold is relatively low. It means that you understand the nature of the charges against you and you're able to assist your public defender in your defense. Does not mean you have to be sane. It just means you have to meet that minimum threshold. And if the defense attorney raises that issue, someone from Western State will come down, evaluate that individual, they will produce a report, and it will say either this person is competent, go ahead and prosecute them, or they are not competent. At that point, we decide whether we want to seek forced treatment of that individual. And for a misdemeanor, we have 29 days to do that. So they could be sent down to Western State for treatment. They will either be restored to competency or not. And for those individuals who are not restored to competency, they cannot be prosecuted. So they committed a crime, and there's nothing that the criminal justice system can do further for them. They are not competent. And some of these individuals have been evaluated and deemed organically incompetent. So there is no amount of forced medication or treatment that can be provided to this individual, certainly within the timeframes available for misdemeanor prosecution, that would render them competent for prosecution through the criminal courts. In that case, there is often a referral to the civil commitment system, and I'm not here to criticize any system, and I don't have really the faintest understanding of how that works. But from the perspective of the prosecutor, we refer lots and lots of people to the civil mental health system, and some of them are committed, many of them are not. And the standard in that system is gravely disabled or danger to self or others. When they are released back on the street, frequently we see those same people within a day or two or a week or a month rearrested. We are then faced with a situation where we have an individual we know cannot be prosecuted. We can hold them in jail, go through the whole process again, evaluate them. At the end, it's likely going to be the same result: dismiss, refer them to the civil system. One of these individuals that we dealt with over the last 2 years, over a period of 800 days, he had spent over 600 of them in the county jail. This is a person through that time one time we tried to restore him and he failed restoration, so he was not, we were not able to prosecute him. But he would still be repeatedly arrested and kept in jail. Early this year, when we had realized that we were just tired not tired of, we had come to a point where we recognized the futility of arresting, prosecuting, holding in jail, and releasing. We gathered together at our office some members of his treatment team, people who were familiar with him, his public defender, from the jail, mental health, got together in a room, and we just talked. We just said, hey, this is where we're at. This is how we've been seeing this individual, and everyone had an opportunity to speak at that. We did not leave that room with any clear plan. We did not have, any grand ideas, and we had no money to do anything other than what we traditionally do. He was not, in the next 8 months, he was arrested twice and spent about 20 days in jail. Simply from the fact that we had gotten together in a room, the people, there were about 6 or 7 people there, the people who had dealt with him from the various aspects of the system: community health, social service, jail, prosecution, and his defense attorney. So I think that was one example of where there might be opportunities for us to begin to address these kind of issues in a different fashion. The second area that I want to talk about is in terms of our sentencing practices at the prosecutor's office. And I saw from your homework exercise that one of the things that was brought up and mentioned was stronger sentences, hold people in jail longer, and you've heard some of the costs associated with that. The average jail sentence or jail stay for a misdemeanant at the city of Everett is 11 days. That means on average, of the 5,000 people that we prosecute every single year, on average, they're out back on the streets in 11 days. The maximum that we can hold any individual on a gross misdemeanor is a year, and that costs the city approximately $24,000. Now, jail is a tool. It can be a very effective tool, and we have put people on a misdemeanor in jail for a year, people who we had been dealing with their cases for a long time. We have had people who we thought were real public safety risks, and it was effective. For some people, getting off the street for a year was enough time to sort out their head and realize they either didn't want to be in Everett anymore or they were going to do something different. But for the most part, we've seen that putting people in jail, while it might be effective in the short term, does not address the underlying issues that cause them to commit crimes. When someone gets out of jail, if they don't have some place to go, if they don't have a home, a family, a plan, $5 to their name, we have seen this time and time again with our cases where we can put them in jail, we can hold them there, we can sentence them, but no matter how long that sentence is, when they're released out on the street, on average after 11 days, if the systems are not in place to help them and assist them after that point, they will be back inside the criminal justice system very quickly. And we will be starting over with them again. And the traditional model that works very well for some crimes, when it comes to these social issues, it tends to just churn people in and out that door. There are a few things that we've identified that can be successful. There's a lot of research that shows that using jail as a tool, short and immediate sanctions on an individual can be effective in altering someone's behavior. If you have a system in place where that individual is accountable to the court, to probation, to that system, and they are held accountable for misbehavior and immediately sanctioned, that has been proven to be effective. Anecdotally, I will say the threat of a lot of jail followed up by intensive supervision can be very effective. And I'm going to transition at this point to say you all had the hypothetical that we prepared as a group to discuss, to start as a discussion about these issues. And in that hypothetical was really a combination of some of the people that we know and work with and see in our course on a day-to-day basis. And realizing that this traditional model is not effective in changing their behavior, one of the things that we looked at was some of the alternatives, including our community justice alternatives calendar. And as a transition, I'm going to yield the floor to Your Honor and let you speak further on that. Thank you.
Well, good afternoon, everybody. I'm Laura VanSlyck. I'm one of two elected judges in Everett Municipal Court. I'm in my first year of my first term at the municipal court, having run last fall to fill a vacant seat left when Judge David Mitchell retired. And Judge Mitchell actually served the court from its inception in 1987, so not a lot of turnover at the Everett Municipal Court in the judge positions. There's a few things that I'm really hoping for this afternoon. The first one is that I really feel a duty in my position to help educate people on how justice is administered in a municipal court. And through that, help you understand it and hopefully promote your confidence in how decisions are being made and about really what judges do. And Everett Municipal Court is extremely busy. Judge Odell and I are on the bench every single day for multiple hearings, and they can involve decisions, everything from pretrial release conditions or bail, motions practice, domestic violence, no contact orders, trials, and we have a lot of trials. And then the ultimate decision following all of that is what do you sentence that person to? Because although the prosecutor can make sentencing recommendations, and oftentimes the defense will make a joint recommendation on sentencing, the final decision lies with the judge, and it is a heavy weight in so many different kinds of cases and so many different kinds of people who come before us. The other thing I really want to do is have this be a learning opportunity for myself in order to gain a feeling of what the community really wants in terms of administration of justice and public safety priorities. It's important for me to get that information. And finally, I will address the Community Justice Alternatives Program that is a therapeutic program in our court. And is this giving a ton of feedback? Am I doing, okay.
Try sitting closer.
Okay, thank you. Before I get started, and I really hope we have enough time for question and answer, because I think that's going to be the most meaningful for you, is to get your questions answered. There are a few things that I may not be able to answer if the question is directed at me. And although I'm happy to, I am restricted in a very, very significant fashion by the Code of Judicial Conduct. And I thought it would be helpful to just point a few of those rules out ahead of time, so that you're not thinking, well, why did she not answer my question? First of all, I don't get to decide what laws are applied in my court. I'm not a legislative branch of government that enacts laws, and I'm not an executive branch of government that enforces the law by filing cases into the court. I take what comes to me. And I don't get to say, I don't like that law, or I think that law is stupid, or this one's really unpopular, I better stay away from that one. I decide every case in front of me on the law and the facts that are presented to me. The second one is any discussion about a particular decision that I've made or the rationale has to be in the courtroom on the record with all parties present. And so I can't, in a setting like this, talk about any individual case or decision that I've made. This one's obvious, but I thought I might as well throw it out there. I'm absolutely prohibited from being in any way biased or prejudiced against any person who appears in front of me. And that's on any basis, whether it's race, gender, religion, disability, or socioeconomic status. I can't make any statements, pledges, promises, or commitments that might affect the outcome of a pending case. And as you've heard, we have lots of pending cases in our court. And I can't make any comment that might be inconsistent with my duty of impartiality. And a lot of people don't know that about judges. It even affects things like which fundraisers we can support. If we're seen to be aligning ourselves with one side of an issue that could come before us, then we're in trouble with the Judicial Conduct Commission. So leaving all that aside, I do want to talk about the CJA program because it's pretty exciting. And this was started through a collaboration between Judge Mitchell and the City Attorney's Office and the law firm that does the city's public defending. So I kind of inherited it in its infancy, if you will, because it started last summer and I started in January. But the program is a collaborative problem-solving approach to these non-felony criminal cases that are in municipal court, and the twin goals are to promote public safety and reduce recidivism. So what we do is we try to address the individual mental health or other issues of each defendant within a supportive courtroom environment. And supportive courtroom environment may sound like an oxymoron. I mean, who here is really comfortable in a courtroom? It's stressful. Everyone's stressed out. But there are people who really cannot function in a traditional model. And the CJA court is more interactive with the judge. There's more time for each case. I take really thorough notes so that I can engage in conversations with people instead of next case, next case, next case. And if you take up my invitation that I'm going to make at the end of my presentation to visit a court hearing, you'll see what I mean. Justice system professionals work as a team to hold defendants accountable while at the same time removing obstacles in order that they can better comply with court mandates. And that, I think Hill really touched on that with the kind of revolving door syndrome. How do we remove those obstacles and get them to start maintaining lawful behavior? Enhancing the participants' mental wellness and breaking those patterns of illegal behaviors are at the heart of the CJA mission and process. The expectations are very clear, and the plans are individualized, but almost always include a combination of treatment and counseling services. We have a new liaison position that we're really excited about that helps connect individuals to the services that are out there, medication, lifestyle changes, and learning new skills. If a person is accepted into the program, their participation is usually around 18 months. And typically they'll come into the court calendar once per month. And they move through the program in a variety of phases. It is a work in progress. I'm tweaking the protocol all the time because I really want to make it the most effective tool possible. For all of you out there who may have questions that I don't have the time to go into detail about, maybe the different phases or things like that, or if you're a service provider and are excited about working with our liaison to get people into your services, I have left my business cards on the table and back. They have my direct line as well as the main line to the court. Please feel free to call me and follow up with any questions. So in conclusion of my remarks, I want to say that I really appreciate the complexity of the issues that this task force is taking on. I am willing to implement practices and procedures that are appropriate and that might be helpful in the court. I'll answer any questions if I can, either now or at a later time. And you are invited to come observe any of my calendars. I'm on the bench every day. I do all of those variety of things, some of which are far more interesting than others. But if you call the court ahead of time, we can get you lined up with maybe what you're interested in coming to observe. So thank you.
Good afternoon, everybody. Thank you again for welcoming us to come and talk to you about the criminal aspect of some of the indigency issues that I know we're all concerned with in the area. It occurred to me as I was sitting here, and I hadn't previously included this in my notes, and pardon me if this is presumptuous, but I'm presuming that the vast majority of us maybe have very little connection with the criminal justice system from a defense perspective, maybe none at all. So what I want to do today is kind of a twofold approach. I want to talk about the role of legal representation for those folks that are commonly identified as indigent or homeless. Pardon me if I interchange those words at times. And talk about the process of legal representation from a defense perspective, exploring the underlying roots that may cause people to engage in criminal behaviors, and then talk about the options that are presented to our clients. Because when it really comes down to it, from a defense perspective, our job is to educate our clients on the criminal charges that are pending against them and to present all of the different options. But when it comes down to it, when you're dealing with someone who has been deemed to be competent and able to assist you in their legal defense, it really is about client choice. And I'll circle around to that when I conclude today. Our appointment begins as public defenders at arraignment. So that's after the police have made their initial contact. It's their first appearance in court, whether or not that be in custody or out of custody, and they're screened for indigency. So at that point, we are talking about a population who does not have the resources to hire their own attorneys. So our office is appointed, or a conflict attorney is appointed, and our representation begins day one. One thing that I think a lot of folks don't realize is that the criminal system moves very, very quickly. You have a right to a jury trial if you're in custody within 60 days, 2 months, or 90 days if you're out of custody. And so we are making contact with clients, especially if they're in custody, within a couple of days. We're going in, if it's a new client, and unfortunately there are folks that we become very, very familiar with over the years and months because they are part of that cycle and end up back in our system time and time again. But we are going in, meeting with clients, talking about legal options, talking about police reports, legal defenses, et cetera, in a very short amount of time. Unfortunately, and I'm going to switch to folks who are in custody, because I think at the point where people are being contacted at a high level on the street, and we're talking about some of those social problems, a lot of times these folks are ending up in jail, held on bail. Oftentimes the bail is nominal. It's $500, which would be $50 to post for an ordinary person. But that bail is insurmountable for most people, and so they're sitting on charges as simple as unlawful camping, criminal trespass, and second degree, which, for many of you, that's hanging out, in the alley outside of your business. And oftentimes, and this may be a surprise for some folks, jail really isn't all that much of a deterrent. And perhaps an even more depressing situation is sometimes I have seen clients who have initiated police contact or put themselves in a position where they may be arrested because if it's a really cold and wet night and you're homeless and hungry, jail might be the safest and best alternative. I'm not saying that's true for everybody, but that is something that I think you should consider when you're viewing, additional jail time as a possible deterrent. When we go in and make contact with clients, we're first of all assessing for competency issues and then talking about all of the legal options. If you're meeting with someone in custody and you tell them our three primary options are continue the case out, so we can help with alternatives, additional resources, treatment, et cetera, plead guilty or go to jury trial, which typically is around 4 to 6 weeks after their initial arraignment in custody. I would say the most common question I get from clients is, what will get me out of jail soonest? And the honest legal advice is oftentimes posting bail, which, as I already said, is a huge barrier for a lot of people, or to enter a guilty plea. And that may seem like a very serious consequence for folks who don't have criminal histories. But unfortunately, with this population, the number of criminal charges that eventually rack up on people's records, honestly, for some folks, what's another one? So what I want to transition into talking about is the consequences of criminal charges leading to that cycle of indigency and continued criminal behavior, and also talk about alternatives and how we've started to broach those with our clients. With criminal charges, there can be very serious barriers to housing, depending on the type of charge. So I have a lot of clients who are willing and wanting to get into alternative housing program, and given, some serious charges, domestic violence related offenses, for example, that can be a huge, sometimes insurmountable barrier. In terms of the fines that are associated with criminal charges, jail time, unfortunately, might be the least of someone's worries when they're talking about having a criminal conviction on their record. All criminal convictions carry at least minimum mandatory fines, if not punitive fines on top of that. And a lot of folks, never get to the point where they're able to pay those off. Oftentimes they go to collections agencies, which have interest rates and everything. And I think the monetary side of the criminal system is not something that a lot of people consider. Another thing is probation. Oftentimes, most cases carry a 2-year probationary period. Domestic violence charges carry a 5-year probationary period. And defense attorneys, in working with their clients and working with the prosecutor's office, formulate terms of probation or conditions of sentences that are designed theoretically to address the underlying issue. And this is a great concept. If you have someone who's continually, stealing wine from Safeway because they have alcohol issues, then it makes sense conceptually to have them get an alcohol and drug evaluation, an assessment, get into treatment, report to probation, because that will address the underlying issue. I hate to bring it back to money, but when you're talking about someone who has so many convictions on their record that they can't get a job, therefore they can't pay for treatment, they can't pay for the assessment, maybe they don't have their DSHS funding or they're not medicated, there's just a list of challenges that we face for getting people, once they've decided to plead guilty, into treatment and into those services. Because the probationary period is so long for some of these charges, there are continued review dates. And so there is a possibility for additional jail time based on probationary sanctions down the road that a lot of folks aren't aware of. That was all really depressing, I'm sorry. So I want to talk about alternatives, and this is where I'm going to circle back to client choice, because I think a lot of folks have a lot of experience with the criminal system, and I'm going to focus on a smaller population of our client base. Those are the people where you pull up their records and, we've represented them on 10, 15, 20 cases in the past. We know these people really well. I think there are alternatives that are becoming more readily available. I'm the defense attorney that's appointed to the CJA court. And there's nothing more rewarding than talking to a client about the change in the court system and the change in the community and the fact that there is more community support for addressing the underlying issues that lead to criminal behavior. CJA is an excellent program that we refer people into. How that process works is when we have a client appointed to us and they exhibit, mental health issues, but they're competent. They may self-identify that they're already engaged in services at Compass Health, et cetera. We screen those folks and refer them to the court and the prosecutor's office to see if they might be a good candidate for a diversion of their program or of their charges. That requires a huge commitment on behalf of the client. And circling back to the unfortunate reality that it might be easier and quicker to get it over with, those are not my words, get it over with by pleading guilty, CJA requires generally about 1.5 years of accountable behavior to the courts. And not only accountable behavior towards the courts, but engagement in services and the willingness to change behavior to address those underlying issues. I have had clients flat out tell me no, they don't want to do it. And at the end of the day, these are adults, competent people who may not see the need or the necessity to change their behavior. And as attorneys, it is not our job to convince people. We're not social workers, we're giving everyone all of the options. But I would say the vast majority of people who have been presented the opportunity to join CJA or to do some other sort of creative diversion program are very enthusiastic. Some people, quite honestly, can't believe that the court system cares about them, that people are willing to sit down and discuss alternatives, and people are very, very hopeful. I had a client in open court mention that no one chooses to end up this way. No one chooses to have a criminal history the length of my arm or to have prostitution convictions or theft convictions. I would say that most of our clients never visualized when they were children that this would be their lives. And so I think it's important to recognize that a lot of folks are willing and ready to change, but when it comes down to it, there is, unfortunately, some distrust of the system on the behalf of a lot of people. And I think that settings like this are incredibly important for changing that perception from a legal perspective. And so I'm very, very excited to be working with the CJA and to continue to work in this community, and I look forward to any questions. Thank you.
Thank you, Laura. Okay, we have about 20 minutes for questions to keep us sort of on time. If that's okay with folks, you can hang in there for 20 minutes. And there's certainly lots of questions you might think to ask here. Remember to use your microphones. I wanted to ask a question. First, it's CJA. No one ever actually told us what that stands for. Can you explain that?
It's the Community Justice Alternatives Council.
Community Justice Alternatives, and it's primarily a drug court?
No.
It's not?
No. It's
A mental health
therapeutic
court? Therapeutic court. For which types of populations?
It's one of the criteria for getting into the program is we have to make a finding that there's a connection between something that's treatable and the criminal conduct. So it can be mental health issues, substance abuse issues, and primarily those are the ones that we see because we need to have a plan in place to address it. We don't just say, okay, come and sit in the courtroom every month, and if you're good, we'll let you go. We're really trying to address those root causes. So it's a little more broad than a specific mental health or drug court.
Okay. And when did that program start?
Was it July last year?
Spring of 2013.
Spring of 2013.
So just over a year ago. Okay. Do folks have questions? I'll just keep asking questions otherwise, but yeah, go ahead. Laura.
Okay, I have a lot of questions, but I will try to keep it down. So one issue that came up in your hypothetical was that somebody might, because they were arrested and placed in custody, and they're being arraigned in custody, they might like the idea of the CJA court, but it's faster for them to get it over with if they plead guilty. So I wonder if there's a way to sort of choose what crimes, maybe collaborating between the police and the prosecutors, what crimes are likely to lead to somebody being in CJA, and maybe decide not to necessarily book those people or not to book them unless the officer sees a safety risk issue, like maybe people shoplift a lot when they have drug problems, and maybe they should be arraigned out of custody so that they're more likely to go into the CJA court. What do you think?
Yeah, sure.
I think in an ideal world, we would be able to coordinate and link people to services immediately through their initial contact with police. But for some of the people in our CJA program and in our courts generally, they are so messed up that they can't just walk in on day one and be ready to enter into a therapeutic problem-solving court. And as I said earlier, jail, in the traditional model, jail is sort of a default sanction for criminal cases. In the therapeutic model, jail is one of the tools. And for some people who are entering into our CJA, there's a period of time where they're in custody just getting sober enough where they can understand that this is a choice that they might want to make. Another way in which jail is a tool in this program is for that individual who says, why should I do this? You know, I have 20 criminal convictions, and the most time I've ever spent in jail is 30 days, and I get out and nobody is up in my business. And that's where I get to come in as part of this team, this CJA team, and say, well, guess what? This time on your criminal trespass 1 charge, we're going to ask for 300 days in jail. And we have you dead to rights because, you know, the investigation was done perfectly, and you can take it to trial, and we're almost guaranteed to win at that case. But here's this alternative. And when somebody who has never spent more than 20, 30 days in jail is looking at a sanction that is much harsher, they begin to think differently about it. So we can use jail as a tool to encourage people into these other programs. So to answer your question, I think there are a lot of opportunities to coordinate between the different aspects of the system and involving police of that, and use jail as a tool, but not necessarily as a default as it has traditionally been used.
Let's take Bob, and then we'll come back to Laura. Go ahead, Bob.
I have two questions, one for the lieutenant and one from Laura. Lieutenant, you mentioned the detox center.
Yes, sir.
And I'm just curious, how large is the detox center? How many patients can it hold, and who runs it?
There's 16 beds, and they've changed a bit over the years. Traditionally, I'm going back probably about, I want to say 10 to 15 years, they've changed from a social to a medical detoxification facility. I really don't know what that means totally, other than the fact that there are protocols to get people in. They've changed as far as medications that they can issue. They're not just alcohol, but they're drug and alcohol. And again, getting back to your first question, 16 beds is the maximum. It used to be that I would go there as a downtown beat officer many years ago, typically on just about every night. I'd have someone that would take down to detox or guide them in the direction of detox, and most of the time they were able to get in. I'm not sure what the capacity was then, but I think it has a lot to do with the fact that they changed to this medical facility, and they maybe lost some beds, I'm not really sure, but I know that it's very seldom used by us as a tool now to get someone off the street that needs help. And then they have pretty strict criteria as far as blood alcohol or substance that's in their blood system as far as whether they're going to take them in or not.
So since Linda Grand is here, who operates this facility, maybe she could speak a little
I hope
bit.
I didn't speak out of turn.
You did very well, actually. We've been running a detox since about 1985.
Can you use your mic, please?
And it's always, well, actually was 15 beds for many years, and we got it stretched to 16 beds a couple years ago. And as the county has grown, it's increasingly inadequate. And so what we ended up doing is converting it to a medical facility, because we had a lot of problems with them bringing medications in as we found more complex people that needed medications to get them through withdrawal. They might have co-occurring mental health disorders. They needed medications for that. And the rules and regulations of the state don't allow you to give medications unless you have nurses on, and we didn't have money for that. So we converted the model to better serve the people in order to get them onto treatment. But the heartburn for us is that we're not a resource to the police like we used to be. And it's really difficult to take them in, which has more to do with lack of capacity than anything else at this point in time. So we have a community that needs probably 30 to 45 detox beds, and we have 16.
That answer your question, sir?
It did, thank you. And then Laura, quick question for you, if I may. What percentage of your clients end up agreeing to work through the CJA program when you explain it to them and you lay that as an option?
I'm going to have to throw Hill under the bus on this. I don't have those numbers. Whoever can help me out here. I really don't have that information.
Laura, yeah, I think you mentioned how you would present the program to your clients, and I'm just curious what percentage.
And I don't have approximate numbers. When I took over the defense side of the CJA, it was probably March, and at that time we had about 15 to 20 open cases. That's not necessarily clients, but number of cases. Now we have slightly over 40. So we've grown exponentially just in the last few months, and that's really exciting. But because the numbers are so small, I would say on average per month we've been referring between 2 and 6 clients to the CJA. At this point, almost all of them have then been accepted. And in terms of the initial conversation between the attorney and the client, we break all of our cases up alphabetically. So the original attorney who may be identifying someone as a potential CJA client is most likely not me. But I would say generally, once an attorney has that initial conversation with someone, the majority of people are willing and excited to be on CJA. far many more than would say no. Whether or not they'll be successful in the long term, because we've only been in existence for about 16 months now, we're just starting to graduate people. So one of the things our new CJA liaison is focusing on is actually tracking those numbers and identifying, success rates and comparing those with hypothetical recidivism rates and everything. So we just don't know at that point, but we'll be tracking it.
Thank you.
Flora, did you want to go to question 2?
Sure. I think I have 2 questions. So one is for Defense Counsel. You mentioned that a lot of times your clients aren't able to go to treatment because they can't afford it. As far as you can tell, is the issue that they're literally not eligible for state or federal medical coverage or treatment payment, or is it possible that they need help applying and they don't even know if they would be eligible if they actually had help through a social worker applying for treatment coverage?
I would say it's probably the latter. And I mean, just since the first of the year, we're still trying to figure out the changes in healthcare coverage, but I've just noticed that a vast more clients do have medical coverage because of the shift in state and federal policy. So I'm optimistic that more and more people will be able to afford treatment. Another thing, to kind of piggyback on that, another issue we see with folks who are in probation oftentimes is that they'll be eligible for treatment and they'll get that initial assessment and they'll start, but given different service providers' policies, there's a potential, if you miss an appointment because you're in jail, or if you miss a class because, you had childcare issues, oftentimes you're defaulted out of the programs and found in non-compliance, and sometimes you have to start over. So I think that's another issue, as well as, the initial financial burden of getting into treatment.
My other question might be, Hill Kamen or Madam, Your Honor, to answer, is that how similar is CJA, if it's similar at all, to what the county does with drug court for felony cases, where they can funnel people into their separate drug court, which, if anybody's not familiar with it, has really excellent recidivism rates, which means people are less likely to commit crimes again if they go through drug court than if they go through the regular superior court system. So is it similar, or is that something that more research would have to be done on?
It's similar. Drug court, obviously, with it handling felonies, there's much more stringent requirements. And I'm pretty sure that, and I know it's been a huge success over the years. The other thing is the identification of who can qualify for the therapeutic setting. And as I had indicated earlier to the question, it can be really anything that we think we can help fix. And so that's a much broader mission than the drug court.
Ken, you've had your assignment.
So a couple of things. Mine aren't questions, mine are more clarifications. You'll hear a lot of talk about...
The mic.
You'll hear a lot of talk about 16 beds, and some of you may wonder, well, why 16 beds? Well, the reason 16 beds is because the federal government, in the Center for Medicaid and Medicare Services, has a regulation that says you cannot use any Medicaid dollars to fund mental health treatment, chemical dependency treatment, or a number of other things if you are in a residential facility, including detox, with more than 16 beds. So most of the facilities now are downsizing, if they haven't already, to 16 beds because the state doesn't have enough money to pay for it, the county doesn't have enough money to pay for it, so we have to depend a lot on the federal Medicaid dollars. And it makes the facility more expensive because of the economies of scale, because you can't go over 16 beds. But if we didn't do that, the programs would have to shut down. There's not enough money. The other issue that I wanted to mention is the different levels of diversion that are potentially available, not all of which are implemented in Snohomish County or in Everett. There is, of course, there's booking restrictions in the jail. That's a form of diversion. And there's pros and cons to each. There's also law enforcement diversion. that can occur, and that's happening somewhat informally, but not formally. There are laws on the books now that allow diversion by law enforcement under certain conditions, and law enforcement can make the decision that they would take the person to a treatment program instead of jail. They have to be non-felony, non-sexual, non-violent crimes. The person has to have a known mental illness or a known substance abuse problem. Very few counties are implementing those. Why? Because the alternatives aren't there. There's no money for the alternatives. So, as was already mentioned, law enforcement used to take to detox. They don't anymore for a variety of reasons, not the least of which is it's always full. Then, of course, you have prosecutorial diversion programs. Prosecutorial diversion programs will, avoid the court, can avoid jail, cheaper than a therapeutic court, but the prosecutor programs don't have as much authority to do sanctions as the specialty courts. Each one of those diversion options gets more and more expensive, which means each one of those options, if it's really going to be cost efficient, needs to look at what clients they're taking. And the more expensive the diversion option, the tougher the client population they ought to be taken. Otherwise, it becomes very expensive.
But just a follow-up question for you, Ken, on that. Sorry, it's okay. So there are other types of diversion programs. They're more expensive than the ones we have in place now, but they're being used in some places that have found the funding, and you think they're effective if money was there?
All of those can be effective if done right. All of them can be fairly efficient if done right. But therapeutic courts as a diversion option they probably have the most pros, but they're also the most expensive. Then you drop down to prosecutorial diversion. That's less expensive than therapeutic courts, but more expensive than law enforcement diversion. So it's a tier. We have therapeutic courts in Snohomish County. At the Superior Court level, we have drug courts. At the district court level, we have a mental health court. Municipal Court, Everett, has their CJA program. And then we also have the prosecutors, Snohomish County Prosecutor's Office, that has the TAP program, Therapeutic Alternatives to Prosecution. And then there is informal law enforcement diversion, but we have not implemented the existing laws related to law enforcement diversion because at this point there aren't places to divert them to. But know that there are laws on the books that we could do something with if we can come together and figure out how to create the alternatives.
And just really quickly, in addition to like no detox beds for diversion, what other gaps are there for that law enforcement diversion program in terms of no places to, if we were going to do it, there would be no places to take people to? What are those no places that don't exist?
If you look at Snohomish County, we have, as Linda Grant already pointed out, one medical detox, 16 beds, always full. We have one 16-bed triage. Compass Health runs it. It's not always full yet, but it's getting there and will be soon. We're in the planning stages with a group of folks in South County to try to open in 2015, hopefully, an additional 16-bed medical detox. That means the people in South County now that are taking up bed space in the Everett detox will be able to be served down in South County once that opens. So incrementally, we need to begin developing the capacity for the alternatives.
Other questions for the group? David?
What do we do now when, Bruce, when you guys pick up someone who's, say, on heroin or in heroin withdrawal, and the jail won't clear them for booking for medical reasons, and the detox facility is full? What do you do with that person?
Well, first we need to evaluate, or have the EMS evaluate them and help us determine what path we're going to take. The jail, we already know what their restrictions are when it comes to, maybe I'm not using the right term, but specialty housing beds. We know that we've got to be cautious when there's known addictions to drugs or alcohol because of fear of medical concerns raised. So a lot of times, if we are going that path of a booking, we're going to go to the hospital first before going to the jail, being told to go to the hospital. Similar to what we would do in a vehicle collision with someone that we're going to book. We go to the jail or to the hospital first. What we do with them if they can't get into the jail is we're going to, if they're medically sound, we're going to look for other options. Are there family members or residents or a hotel that they can go to? We may assist with transport to that. We may get them in touch with the taxi. We're pretty limited in options. I mean, I believe Mr. Stark already talked about that, but we're very limited in what we can do at that point. See if I'm missing something, but I think I'm out of options.
Bob, you had a question. I'm sorry not to get
I
to you
wanted to
sooner.
make sure something was recorded, was said earlier. From a prosecutor's perspective, what is the ideal world? Hill, you stated it, but I would like to have it a question and an answer.
Is that a prosecutor question, sir?
Yeah, it's a prosecutor it's a prosecutor. Hill, you said, you started your statement earlier, you said in an ideal world.
And now I don't remember what the answer was.
It had something to do with linking individuals with services upon arrest, and you said, and then you went on to tell what really happened.
Well, I do think that there is a real opportunity with that kind of linking people with services before they get into the court system. Because as David addressed, that moment they enter into the court system, there are these additional costs associated with that. And a lot of what we talked about today and diversions, the whole point of diversion is to get people out of the criminal justice system, which is expensive and ineffective at addressing the underlying social issues, into treatment or community resources that are available. Now, it's certainly been mentioned that there are gaps and limitations in those community resources. But the criminal justice system should be used as a tool where it is most effective. And if the community systems are more effective at addressing those social issues, then we in the criminal justice system should develop procedures and protocols for getting people, the appropriate candidates, out of the courts and out of police and into those systems. And I just want to say something about a comment that Ken said about therapeutic courts and them being most expensive. And in an ideal world, our court would have a huge budget and we could help assist all of these people get into court system, and that would greatly enhance our ability to see success with these individuals. But that's not always the case. And when we started the CJA program, we said, wow, we have a lot of people in jail for really petty crimes or relatively petty crimes, and they may not be petty to the victims of these crimes, trespassing and shoplift and theft, and but it's expensive and it's not changing anything. But we have no money. So what we did is say, hey, let's just take the best practices of therapeutic courts, an environment where the judge holds a person accountable, where there's a team collaborative approach, and that we have targeted, individualized plans for each of the people in there. And we began to see success with no money. And as we did that, we've now been able to bring a liaison on board and would be able to show that that works. So I would say that while therapeutic court programs are expensive, looking forward, and there's a lot of different areas where our office is going to look for creative solutions, we should look at ways in which we can come to a resolution or solution that is simply brought about by the collaboration of the parties who are already working in this system. Because the people who are there are already there, and we're already there, and so ways in which we can accomplish those goals most effectively can be done with the resources we have. And obviously, there are places where those resources should be spent, and we should find the most effective way to do that.
Thank you, Hill.
Could I follow up real quick?
Yeah.
I don't feel like I answered your question totally. the answer to, when we run out of options, we went to book someone into jail, we can't because of addiction issues. Many times, and we do this almost daily, warrants are re-entered into the system if that person's entered on or arrested on a warrant. If the decision to book on a felony charge was made, and that's not something we'd ask for as an exceptional booking, then that is something we're going to write up as probable cause to the prosecutor's office to charge. So they're still going to be held accountable, but the tough answer is that they're released back into society, if you will.
Ken?
So my follow-up is tied to, when I was talking about therapeutic courts being expensive, they're an expensive form of diversion, but a heck of a lot cheaper than what we're doing now without it. So I want to make sure that people got that. I also want to mention that when you as a either paramedic for EMS or law enforcement run into one of these individuals, and it's not an acute medical condition, but your only alternative at this point is to take them to the hospital emergency room. I don't know how many of you know how much that cost, but an average cost of a hospital emergency room is probably $3,000 to $4,000 for these individuals. If we had detox capacity, it would be about $252 a day, a whole lot cheaper. So we as a community, not just Everett, but the whole state of Washington, need to figure out how we start getting people to the system that is going to most effectively meet their needs, rather than the billions and billions of dollars nationally that are being spent on things that don't work. So just a message to think about.
Thank you, Ken. I think we're, Cassie.
I just wanted to add that in the juvenile justice system, we actually have some pretty effective diversion programs that are funded by Snohomish County, and we partner very closely with juvenile courts, and there's an excellent drug court in the juvenile justice system, and it reduces recidivism, and we partner with them so that young offenders can be brought to our programs as long as it's not, aggressive assault charges and things like that. There are some barriers, though, that just exist in the laws once it enters into like a domestic violence thing. The law enforcement has to bring them into juvenile justice first, rather than being able to bring them directly to Cocoon House, which is unfortunate because it is it becomes a very expensive option, and then these young offenders have a criminal history, which will cause barriers for housing later on. And so we are, certainly working to partner with those systems, but there's some barriers that we as service providers and law enforcement, our hands are tied right now because of the laws that exist.
Great. We have held you all now longer than I promised, so I'm going to let you go here with two reminders. Think about, we'll come back at the end. If you would like to create a subcommittee to sort of work more on bringing back a focused set of recommendations for consideration by this task force, we'll take that up when you get back in 10 minutes. So like when that clock, which is a little fast, says it's like 2 minutes to 5, we should all be back in our seats. And also remember to sign up for, if you're task force members, sign up for a tour if you have the opportunity while we're on the break now. Okay? Thank you. And thanks to our panel. Can we get, without killing the microphones, a round of applause for our panelists.